Good morning. My name is Simon Passfield, and I'm the head of the Insolvency team at Guildhall Chambers. I'm joined today by Govinder Chambay, who's a member of our Insolvency and Commercial teams. Over the course of the next hour or so, we are going to be considering contested administration applications. We, and I use that term liberally because I largely mean Govinder, have prepared a comprehensive paper to accompany this webinar, which will be circulated in due course. But in the time available to us this morning, we wanted to focus on four key areas. The first are creditors' administration applications, where the company disputes that the applicant is in fact a creditor with standing to bring the application in the first place. The second is administration applications by the debtor company or its directors, where one or more creditors oppose the making of an administration order. Third, we will look at bun fights over who should be appointed as administrators, both in the context of disputes between the director's nominee on the one hand and the creditors on the other, but also cases in which there are disputes between the creditors themselves. And finally, we'll briefly touch upon costs in the context of disputed administration applications. I'll turn now to Govinder, who's going to start to address the first of those four topics.
Well, thank you everybody for attending this webinar and Simon for doing the introductions. Simon touched upon just a moment ago, we're talking now in the context of a creditor who's got a disputed debt that wishes to place a company into administration. The short point is that a creditor with a disputed debt has standing to present an administration application, provided that they can show a good arguable case that they're owed a debt of sufficient amount. So the starting point is to consider firstly whether you've actually reached that threshold, and that's a merit-based assessment which you do behind closed doors before deciding to present an administration application. Now here's the rub. Just because, well, let's say, for instance, that the court decides that you do have a good arguable case and therefore you've surpassed the standing hurdle, that doesn't necessarily mean that you're a creditor for the purposes of section 1231A, or indeed that your debt is a debt or a liability that should be taken into account for the purposes of 1231E or 2. Now you might ask, well, what is the purpose of having a rule that affords you standing if, when it comes to a later crucial question, that there's a risk that you're not even actually a creditor? Well, I think the answer lies in a couple of points. And that firstly, Hammonds confirms that the court can make an administration order on the basis of a disputed debt without having to resolve the issue about the disputed debt. So if we look at some of the potential outcomes, the first one could simply be, well, you haven't established insolvency. The second one is that the court actually grasps the nettle and resolves the issue of the disputed debt whilst leaving the application pending, as well as any declaration as to solvency. And the third point is that the creditor can actually point to other debts or, for instance, sort of deficiencies in the company's balance sheet. And I think that must be what the court was talking about when it was saying that we can still make the administration order without having to resolve that issue. So it's about being able to point to other matters. So practically, where does that leave us? Well, there is an informational asymmetry as regards a creditor and a company, and indeed a director. You're not going to know as much about the company's affairs, at least not in comparison to the director. So the key, it would seem, is to obtain as much publicly available information as you possibly can. So we're talking company's house, and it's also worth considering the judgment register. Now, it may also be that there are other creditors with unfulfilled demands or indeed intel, and I suspect that would be useful in cases where you've got access to creditors of a similar sort of class. So think perhaps a bar where you've got other supply creditors who have also had difficulties in getting their invoices satisfied. Moving away from that for just a moment, it's actually harder, I think, for creditors to establish balance sheet insolvency. There's a temptation to think that, well, all one needs to really do is simply do assets minus liabilities. That's it, company balance sheet insolvent. But it's actually a far more nuanced test, and where, of course, actually looking at whether in practical terms there's incurable deficiencies in the company's assets such that it's unable to pay its debts. That is going to be difficult to show when you don't have an intimate knowledge of the company's affairs, and that's why there's a lot of emphasis upon obtaining that sort of publicly available information. And of course, directors are going to have the upper hand, I think, on this, because they do have intimate knowledge of the company's affairs, and they are able to sort of point to things that a creditor wouldn't know.
I think Govinder is right to say, isn't it, as well, that the other thing that feeds into that is, of course, it's quite difficult as a creditor to put together an administration application in respect of a company, because not only, as we'll come to see, will you need to establish that the company is insolvent, but you also need to demonstrate that a purpose of administration can be achieved and find insolvency practitioners who'd be willing to act as administrators. And it's obviously a lot easier for the company to be able to open up its books and records to licensed IPs, who can then work out a strategy as to how they might carry out the administration of the company. It's, of course, a lot more difficult if what is being said is, I believe that this debtor of mine is an insolvent company, and I'd like you to confirm that you consider that you would be able to achieve a purpose of administration and therefore be willing to take an appointment, because you just don't necessarily have access to the information, which I suspect is why we have perishingly few administration applications made by creditors rather than by the companies themselves.
So I think that covers the case of a creditor who wishes to place a company into administration. But now on the flip side, we're going back to a point which Simon just made about this information that's available. It's entirely different when it's indeed a director of the company who does have intimate knowledge of the company's affairs. And what Simon's going to take you through now is a director-led application which is opposed by a creditor.
Yes, so where the company itself is seeking to be placed into administration, there's obviously a number of different factual scenarios in which that may arise. But the most beneficent example would be a case in which the company's directors recognise that the company is insolvent. They believe that one of the purposes of administration could be achieved, that liquidation therefore would be a step too far and indeed would have a worse outcome for creditors, for employees. Those sorts of scenarios are unlikely to be ones in which you will find that there is a large contest. More likely is going to be your scenario where the administration application is a reactionary one. In circumstances where, for example, a creditor has presented a winding up petition or is placing other commercial pressure on the company, and the company wishes to enter into administration to defeat a potential liquidation and also secure the appointment of their own choice of insolvency practitioners as administrators. We've highlighted two other potential cases in which an administration application may be made by the company or its directors on the slides. The first is where the qualifying floating charge holder may be unwilling to make the appointment themselves, or there may be some concern on their part about the validity of their charge, in which case they may leave it up to the directors. The final one on the slide is perhaps a slightly more cynical example where, as we'll come to see, the directors may be concerned that if the company were to move into compulsory liquidation, certain dispositions made after the presentation of the petition could be retrospectively avoided, which wouldn't be the case in the event of an administration order being made. And so therefore it may be a tactical ploy to seek to avoid the consequences of that. But focusing on the most likely scenario, that where a winding up petition has been presented, and in response the directors have caused the company or themselves applied for an administration order, it's pretty obvious that in those cases there's unlikely to be any real dispute that the company is insolvent. And so the real issues for the court on considering the application are going to centre around two things. Firstly, whether the purpose of administration can be achieved. That is to say, does the court have jurisdiction to make an administration order? And if so, secondly, whether the court should exercise its discretion to make the administration order sought, or instead should do something else. Now, by way of reminder, under paragraph 3, subparagraph 1 of Schedule B1 to the Insolvency Act 1986, an administrator of a company must perform their functions with one of 3 objectives, which are hierarchical, meaning that the administrator can only pursue the second and third objective if they conclude that the preceding objectives are not reasonably likely to be achieved. The first objective, of course, is to rescue the company as a going concern, as distinct from its business. That is a purpose which is pursued in a vanishingly small minority of cases. The second and most common purpose usually pursued by administrators, of course, is to achieve a better result for the company's creditors as a whole than would be likely if the company were wound up without first being administration. If that cannot be achieved, then an administrator may perform their functions for the purpose of realising property in order to make a distribution to one or more secured or preferential creditors. Now, under paragraph 11b of Schedule B1, the court only has jurisdiction to make an administration order if it's satisfied that the administration is reasonably likely to achieve one of those purposes. That has been interpreted as being a real prospect test. So essentially, the exercise is akin to summary judgment. The applicant needs to demonstrate that the prospect of one of those purposes being achieved is beyond fanciful or merely arguable. Where an administrator proposes to achieve purpose B, which, as I've said, is the most common purpose, the exercise which the court is required to undertake is to make a direct comparison, in effect, between the likely outcome in administration versus the likely outcome in an immediate compulsory liquidation. Now, that is usually achieved by considering the estimated outcome statements that will be prepared by the applicant, demonstrating what those likely outcomes are. Historically, those who've been practicing for more than a few years will know, it was always argued that in any case where there was a prospect of the unsecured creditors seeing something out of an insolvency process, administration would always achieve a better result than immediate liquidation, because in administration, the administrators would not be required to pay the ad valorem charges to the insolvency service that then applied in liquidation. And so for a number of years, it was easy to make out the case that administration would always be better in a case where, all things being equal, it wasn't clear whether, as a process, administration was any real different from a liquidation. By that I mean it wasn't a case where the office holder was seeking to use, for example, the protection of the moratorium to continue trading and effect a pre-pack sale, but where really it was a closed down job, and the question was just simply which of the two processes should be favoured. Since the abolition of ad valorem fees, of course, that argument is no longer a good one, or at least it's not necessarily the case. It can always be said that administration will be more cost effective than liquidation. And of course, also note that the point which I've alluded to already, that in a case where the company has made dispositions of property after the presentation of the winding up petition, in fact, administration may result in a worse outcome for unsecured creditors, because in administration there will be no immediate claim to recover any dispositions out, whereas in compulsory liquidation the company would have a restitutionary right to recoup any dispositions paid out by virtue of the retrospective avoiding of those dispositions by section 127 of the Act. In most cases, certainly in my experience, an applicant for an administration order will say, as a last refuge of the damned, even if the court is not satisfied that either purpose A or purpose B can be achieved, it will be possible to achieve purpose C. That's to say, I will be able to make realisations for one or more secured or preferential creditors. And on that basis, the jurisdiction to make a winding up order is engaged, and it's then a question for the court's exercise of discretion. But it's worth noting that in order to pursue paragraph 3C purpose, by paragraph 3(4)(b), it must be the case that the administrators will not thereby unnecessarily harm the interests of creditors as a whole. And the limits of this were rather neatly illustrated by a case in which I was involved, which is on the slides, the case of Baltic House Developments Limited. In that case, I acted for petitioning creditors who opposed the making of administration order. The company had rather cynically, in response to the petition, issued its application. The original proposed administrators nominated by the company indicated that they thought that purpose B could be achieved because they thought, on the information they'd been given, that the company had £5 million of realisable debts. When they investigated further, they concluded that, in fact, there was no prospect of recovering any of those debts. Purpose B could not be achieved. And in the face of significant creditor opposition, because there were over 100 creditors supporting the opposition of the petitioners, those administrators were not prepared any longer to act as administrators. What then happened is that a new firm indicated they were prepared to take the job on the basis they felt they could pursue purpose C. Now, in response to that, what the petitioners did, and perhaps slightly uniquely, is put forward evidence from yet another IP who said that if she was appointed as liquidator, she would be prepared to act on the basis that, in terms of remuneration, she would receive the lesser of 10% of realizations or a fixed fee, which fixed fee would be set at whatever sum was less than the amount the administrators were proposing to charge. Now, it might be thought at first blush that that's a slightly cynical response, but the judge in that case, His Honour Judge Eyre, as he then was, Mr. Justice Eyre as now is, had no difficulty in finding that in the circumstances, on those unusual facts, because liquidation would be cheaper than administration, and administration would unnecessarily harm the interests of the company's creditors. And so on that footing, therefore, it was not possible to achieve purpose C, that being the only purpose contended for. The court could not be satisfied that there was a real prospect that an administration order would achieve the purpose of administration. And so therefore the court had no jurisdiction to make an administration order. And therefore the only option was to call on the petition and make a winding up order thereon. In terms of the evidence that is required to make out the applicant's case, as I've indicated, the test is whether there's a real prospect of achieving one or more of the purposes. And in this regard, the burden is, of course, on the applicant in the case in which we're envisaging the debtor company. So there's therefore a need on the part of the directors to ensure that the company puts forward cogent and compelling evidence. Now, in practice, what this will usually require is either a report, but ideally a witness statement from the nominee administrator, setting out in detail the way in which it's envisaged the purpose will be achieved and the reasons why it's believed that that purpose can be achieved by carrying out those steps. Now, the court is likely to place a high degree of weight on the views of a licensed IP, but it will still need to interrogate the evidence. By that, I mean the underlying financial and documentary matrix to satisfy itself that the conclusion which the IP has reached is a reasonable one. So where it is said, I believe that I will be able to achieve a better return for creditors because, it's very much the scrutiny of the reasons that make up that because. Now, what evidence is required by the company in this regard will obviously depend on a case-by-case basis. But where it's clear that there's likely to be opposition from the creditors, then it's naturally sensible for the company to put forward as much information as possible. Because ultimately, as Govinder's already indicated, the directors will be in possession of the full financial workup. They'll be the ones who can provide the information to assist the court, and it's incumbent upon them to try and ensure that they do that. Because a judge may well have difficulty in supporting a conclusion the purpose can be achieved if the information that's put forward is not full and frank. And that's the point that's made in some of the quotes we set out on the slide. Now, of course, from the opposing creditor's perspective, it may be a tall order to persuade the court that the purpose cannot be achieved, because, of course, the test being a summary judgment one, it would be necessary for the court to be satisfied that the company failed to limp over that fairly low hurdle. And obviously, given the paucity of information, or the imbalance in the information between the company on the one hand and the creditors on the other, that may be an uphill task. And it may be in many cases that the creditors are left focusing their firepower on the issue of discretion. Yes, the company has just about demonstrated a purpose could be achieved, but that's not enough. But nevertheless, it's important to carefully scrutinise what comes forward from the company, because there may be some obvious points that can be made, obvious inferences that can be drawn. And of course, as we saw the most extreme example in the Baltic House, it may be possible for the creditors to produce their own evidence to countervail or to gainsay some of the propositions put forward by the company itself. That then addresses the question of jurisdiction. Assuming that the court is satisfied there is jurisdiction, the question then arises of discretion, which I'll now turn to Govinder to address.
So we see that the court has, in terms of discretion, very wide powers on hearing an administration application. Paragraphs A to C are fairly self-explanatory in what one would reasonably expect. It's actually paragraphs D, E, and F which really bring out the court's power to consider alternative insolvency processes, and which draws together the points that are made about void dispositions and such like. The starting point is that the discretion to make an administration order is very wide, and indeed it should take account of all relevant parties and the purpose of the legislation. And this is where someone's right to say this is where you may have a better chance of sort of firepower. And I say that because certainly in Baltic, it was conceived to be a relevant factor that if the views of the creditors are that they are pressing for a liquidation, that's going to weigh in the court's mind, because, of course, you can treat it as almost, we know how our interests are going to be served, it's going to be in our benefit, and we want a liquidation as opposed to an administration. That there is also essentially that comparative exercise that what's the extent to which an admin is going to produce a worse outcome, or indeed, is the outcome going to be worse in an administration as opposed to a liquidation? So now we're thinking about cost and delay. But there's also more pragmatic factors that are sort of put in, and we can sort of see the court taking a bit more of a paternalistic stance. And that's it's not implausible that you may well have a case where the benefits of an administration are trivial as compared to a liquidation. And what the court is perfectly able to do is to say, well, in those circumstances, the creditors should really be entitled to the independence and indeed the objectivity of the official receiver. There's no real countervailing benefit of an administration that bears any weight against that, so we'll opt for a liquidation instead. So really, the points there are to sort of highlight, once you've received the company's evidence, to highlight, well, look, this is the extent to which we're going to receive a benefit. It doesn't bear any real relationship overall. It's also the case that a court may well prefer a liquidation because the company's affairs may indeed warrant a comprehensive examination. Now, of course, that's going to be somewhat difficult unless you can establish sufficient grounds for saying there is something unusual going on. It may be that you can draw that inference from the financial workup that's provided by the company. It's really void dispositions where we see the court exercising its sort of wider powers, because what the court's able to do is call on the hearing of the winding up petition. It will recognise there's this issue about void dispositions, and so what it can do is appoint a provisional liquidator who can then investigate And it also provides some protection to the company's assets, and that provisional liquidator can thereafter make any application for validation as needs be. But what the court's not going to do when it's concerned about void dispositions is actually treat the administration application as a winding up petition, because in those circumstances, if it then goes on to make a winding up order, the winding up is actually deemed to commence on the making of that order, as opposed to the presentation of the petition. So it's pretty self-defeating. So
just a couple of further thoughts on those points, Govinder. The Office Serve Technologies case, which we refer to on the slide, which is worth a read, not least because it's a judgment of the late Judge Pearl, where the opening line was voted, I think, one of the greatest opening lines of a judgment from the last century. But more importantly, the judge made the observation in that case that it's often overlooked that liquidators do have powers to trade a company in certain circumstances. And so in that case, where there had been quite a significant amount of void dispositions made by the company after the presentation of the petition, he considered that that was the single greatest factor that meant the company should enter into liquidation rather than administration, notwithstanding arguments from the directors that that may have a terminal effect on the company. And we see that come to fruition. And in the later Office Serve judgment, Office Serve and Annabelle's and others, where the liquidators were then able to recover dispositions from multiple recipients, which would not otherwise have been available to them if the company had entered into administration. The second thought, perhaps unusually, but as a result of very recent case law, is that another possibility in terms of the exercise of discretion is that it may be that the court decides it's not appropriate to make an administration order, not because it considers that liquidation is the better alternative, but rather because one or more creditors wish for the company to enter into a restructuring plan under the new Part 26A of the Companies Act. And the reason I say that is because in the judgment handed down last week in a case called NGI Systems and Solutions Limited and the Good Box Collabs Limited, the citation is 2023 EWHC 274 Chancery. The case is in the notes that will come out in due course. In that case, Judge Davis White QC directed administrators of a company to cause it to put forward a restructuring plan on terms proposed by a creditor in circumstances where that would result in a better outcome for certain creditors, and the creditors as a whole were left in no worse position than they would have been in administration. So again, it seems to be possible in the future that you may end up having contested applications where, in fact, certain creditors are saying this should not be in administration, it should be in a restructuring plan. And it seems that's a process that can now be driven, surprisingly, for what should be a debtor in possession process, by the creditors themselves rather than by the debtor company.
Well, having covered the sort of discretionary aspect, let's just assume for just a moment that now we've passed the issue of standing, we've passed the issue of jurisdiction. It's not infrequent that the court has to actually decide who it is that should be appointed, and those disputes can sometimes be between creditors themselves, and indeed sometimes it can be between the company or indeed the director's nominee and the creditor's nominee. And there's a fairly long line of case law that sets out a lot of the principles which Simon's going to take us through.
Yeah, so in terms of who should be appointed as an administrator, the principles which the court will apply ape those which have applied historically to liquidators. And the key points is that generally the court will favour the view of the majority of creditors, because ultimately it is the creditors in whose interest the administration or liquidation will be conducted. But it's right to note that that is not an absolute rule. The majority of creditors do not have an absolute right as to the choice of administrator or liquidator. The reason for that is that the office holder must be someone who is independent and who has no conflicts of interest. in the sense that they should not be the nominee of someone who has a interest which conflicts with or a duty which conflicts with those of the liquidators. And specific examples of that would, of course, be someone against whom the company has hostile conflicting claims, or indeed someone whose conduct requires investigation. Now, so far so standard, because ultimately anybody who is appointed will be a licensed insolvency practitioner. The court proceeds on the assumption that any licensed IP will act with integrity and will be able to exercise independent judgment irrespective of who nominated their appointment. But the additional key factor, which we find on the next slide, is that justice must be seen to be done as well as having been done. And that's a fairly standard equitable principle that permeates the law at large and has done for centuries. What that means in practical terms, therefore, is that notwithstanding the strong policy argument that any appointed IP would do the same job, you can see how creditors, particularly significant minority creditors, could be severely disenfranchised and disillusioned with the entire process if the feeling is that the person who's been appointed to do the job is someone who in some way is tainted by association with their connection to the company or others. And so that's another core principle, which we'll see in a moment when Govinder takes us through some of the cases, has factored into the court's reasoning when it's come to determining disputes as to the identity of who should be the administrator.
So we're looking here at creditor v creditor. Now, the starting point is that it's the majority by value that's going to prevail, and that's only if all else is equal. So, as Simon rightly identified, the majority of view doesn't bind the court who has the final say. It may just be, as it was in healthcare, that there are no other countervailing views. And some of those countervailing views can be, for instance, a nominated person may have already made some progress in getting to grips with the company's affairs. And so you would say, well, hold on, this is just going to cause a huge amount of delay and cost in having somebody start from scratch when all that work that's been done in the interim has gone to waste. So it's better for everybody all round that the person who's started to make headway carries on. It just so happened that in healthcare, those countervailing views weren't there. Now, what that leads is generally, as a principle, the court's going to prefer the appointment of a candidate who's already familiar with the company's affairs, just on the basis of common sense that, as I say, it saves a lot of time and cost. But there's also, again, on this practical line of thinking, resource questions. If you've got, as I say in the slides, a relatively complex administration, but you've got an international firm with all the resources available to it, you would think that's going to be much more attractive to the court as opposed to a smaller sort of sized firm, or indeed a one-man band. That's going to not be as attractive. And there's also this point about the number of administrators, but I mean, it can work both ways, but especially in the case of a smaller sized firm or indeed in a one-man band, if the proposed administrator is working on something else, the admin process is essentially ground to a halt for that time being. Whereas if you've got one or more, work can continue in the background. So what we want to be looking at really in these sorts of cases, the points you want to be taking are that certainly work and effort has already been taken. The resources are better equipped to deal with this type of administration. And indeed, if it's necessary or it's appropriate, that our number of administrators means the job is going to get done quicker. And those are all things that are going to be attractive to a court because it just suggests the less time and delay. And it's, of course, in the public interest that insolvency proceedings are resolved as efficiently and as quickly as possible. What is sort of difficult, though, is this sort of point about demonstrating the lack of confidence. So we're going back to the Med Gourmet about justice being seen to be done. So there was a case, Stanley International Betting, where we have two substantial creditors. And the rub was that essentially we couldn't determine who the majority creditor was. And in the end, it was C1's choice that was appointed. And what the court found was that C2 hadn't actually established that the creditors at large couldn't have confidence that C1's choice would actually conduct a thorough and sort of vigorous investigation. It seems to me that it was an unusual case because we don't know who the majority creditor was. And you would say that if we did know who the majority creditor was, that would make the issue a whole lot simpler. What I find troubling about this sort of case is that justice being seen to be done, we would say, would warrant C2's choice being appointed, because it's very, very hard to challenge the integrity of someone else's nominee unless you've got actual evidence there before you. You know, a suspicion, it would seem from this case, isn't enough. So those are some of the sort of principles that apply in the case of creditor versus creditor. And Simon's going to take us through when it's a company or indeed director nominee versus a creditor's nominee and how that works.
So starting with a simple proposition, if this is a straight bun fight between the IP nominated by the director stroke the company and a proposed alternative by one or more creditors, the starting point is that the creditor's nominee will usually prevail. And one can see easily why that is the starting point, because as we've seen, the overarching principles include that justice ought to be seen to be done, and that the view of the majority of creditors should usually carry the greatest weight, because ultimately they're the ones with the economic interest in the administration. Now, as with a lot of the principles we looked at this morning, that's not an absolute rule. There is a discretion on the part of the court to favour the director's nominee, and in some cases the court may well conclude it is appropriate to go with the company's choice, particularly where they have some familiarity with the company's business. Slightly less than convinced by myself that that in of itself is sufficient, but more likely in those cases where it is said by the company, our proposed IPs have hit the ground running. They've done a considerable amount of work, which would need to be duplicated if a new set of IPs come in. They are in a position to achieve the purpose because they have done certain things. Most obviously, for example, they've conducted a thorough marketing exercise of the company's business and assets. They would be ready to effect a prepackaged sale or near prepackaged sale. A lot of that would need to be undone or redone if someone else comes in. But of course, that's not determinative, because the court still needs to balance those sorts of considerations against the need for justice to be seen to be done. Again, every case will turn on its own individual facts. As Govinder has already alluded to in the context of creditor disputes, resources is also a potentially relevant factor, because of course, if, for example, the company have nominated a well-resourced firm to act and one of the creditors says, I don't want them because they're the administrator's choice, I instead want Joe Bloggings, who is a one-man band, who takes on one appointment a year and has no particular expertise in this field, well, then the court will have to naturally take into account, in assessing who's best placed to carry out the administration, those sorts of considerations. Looking at some illustrative examples in the cases, and they are but illustrative examples, in the GP Noble Trustees case, which you have on the slide, that was a case in which the creditor's candidate was chosen over the director's candidate, notwithstanding the arguments being run by the directors that our proposed nominee is already familiar with the company's affairs and therefore is in a good position to act quickly. Critically, in that case, there wasn't any evidence to suggest that, in fact, economies of scale would arise as a result of the director's nominee having prior knowledge. And again, we see this all weighing into the balance. Another relevant factor is that the opposing creditor, who had their own nominee, was a very substantial creditor and a trustee of an occupational pension scheme with duty to the employers present and future. And that led the court in that case to say that it's important in those circumstances, it should be seen that there's a rigorous and independent professional analysis of what is in the best interest of the creditors by whichever administrators are appointed. further illustration of that principle coming to the fore is the Oracle and Pinnacle case itself, which we've already mentioned or touched upon. That was a case in which it was a straight bun fight between the company's nominee on the one hand and the nominee of some of the other creditors. The secured creditors were entirely neutral, so there was nobody before the court who was advocating, in terms of the creditor side, who's advocating for anyone other than their nominee. That was perhaps a straightforward case for the application of the relevant principles, that the court should favour the interests of the creditors, notwithstanding the concerns that the director's nominee had prior knowledge. Because, of course, ultimately, the administration is being conducted for the creditors. And so in a case where the only people straining themselves to turn up to court to actively argue the toss say that open-eyed they want to have a particular nominee, even though that may be more costly than the director's nominee, even though it may take more time, then in those circumstances you can see why the court would suggest they ought to have their say. Things become murkier and more difficult in circumstances where it's not a straight bum fight, where actually there are creditors who wish to support the director's nominee. And I'll touch upon that in a moment after Govinder's looked at the issue of headcount in the context of a case I was involved in that was particularly tricky and murky. But I think ultimately the key point to note is that when you find yourself acting on either side of the equation, whether it be for a director, stroke company, or the creditors, it's important to identify the sorts of arguments that would support the appointment of your nominee out of the morass of factors that the court takes into account. But each case is going to be discrete in terms of its facts, and therefore when it comes to advising, there has to be an element of reality to what the court's likely to do. And I think it's fair to say that the wind generally blows towards the creditors having their say. It's not absolute, as I've indicated, and there may be factors that can be relied upon, but ordinarily, unless there's some really compelling evidence that the company's nominee is so advanced and has hit the ground running so much that no one else could step in and take over at that critical juncture, the likely it is that probably majority creditor view will prevail. But I'll come back to argue against myself in a moment by reference to a recent case. But before I do, Govinder's going to take us through the question of headcount.
Thanks, Simon. We've talked a great deal about creditors' views, and it's in world-class homes where the court actually took a step back for just a moment and asked itself the question, well, okay, should we conduct this head count of the creditors to see who it is that should be appointed? And the court made the point that it's all good and well that you've got creditors who've expressed views, but it's a question of weight, and you don't know what weight to actually attach to that preference if indeed you don't know what was said to them. So the example given here is that if, for example, a creditor is told that the only prospect of getting a decent recovery is to have Mr. A as administrator, that could have procured a support for Mr. A, even if it transpires that Mr. B would be quite as good as Mr. A. So you can see how the court's thinking, well, I can't attach much weight to your preference if the origins of that preference are a little bit skewed to start with. So one of the important points that you can take is, well, do we know what was actually said to creditors? Do we know why they suddenly have a preference for Mr. A as opposed to Mr. B? And one would wonder that perhaps the way around that is essentially transparency, a simple sort of explanation of this is why we say that X and Y and Z administrator is better for us, and this is what's being explained to us. So the court can then attach some weight to it. And then this is what the court was sort of referring to when it sort of said that a head count can work if it's properly explained to the creditor. So here the court makes clear that if the weight of this head count was one way and was well explained, the court can then attach some weight to it. And I think this feeds back into the point that Simon was making there. You've got the views of creditors, but they're actually views that you can attach weight to because everything adds up. They're not proceeding on a flawed premise. And I think that's the key point when it comes to headcount. You can see it working on both sides of the fence. You would be certainly if you for the director, but taking the point that, well, hold on, we don't know what was said to the creditors. There's only, I think it's unlikely that the court's going to attach no weight to the views expressed by creditors, but what you would simply say is that when weighing things up in the round, there's not a great amount of weight that you can attach to it because we don't know what was said. And so we don't know there's no how realistic it is that that's their informed view. Equally, if you're for the creditor and you're nominee appointed, you're going to have to explain why you've taken that view. We'll want to have that set out in evidence of some form in terms of the explanation that you've received, so you can suggest to the court that actually there is a fair amount of weight that can be attached to it, and indeed the conclusions that have been drawn are reasonable conclusions to draw. And it's then that question, that balance between is there somebody who has made some headway with the company, or is it somebody who should be appointed for whose benefit the administration actually is? And I can certainly see that it's unlikely that an administrator is going to have really made huge amounts of headway, just because of the nature of these sorts of things. It's not going to be, I would have thought, an amount of work that makes it entirely obvious that only that administrator can actually go on to conduct the rest of the administration, because by reason of the volume of the work that they've conducted, it's likely we're going to be talking small margins, I think. So that's what I've got to say about headcount. I think Simon was going to.
Yes, before I look at the question of joint appointment, I just wanted to draw this together because most of these principles, they're fairly intuitive. And as you'd expect, there's no absolute positions. The court has a very wide discretion, and there's certain factors that are taken into account, and the judge does the best they can applying the principles and looking at the facts of the particular case. And in a lot of cases, it'll be quite a straightforward exercise, because you'll probably have two competing potential appointees or groups of appointees, and ideally, in most cases, headcount on a rough and ready basis will probably get you to where you need to get to. But what happens in a slightly more unusual case? Well, I offer this up just by way of a case example. A case I was involved in at the back end of 2021 called High Street GRP Limited. This was a case that was ultimately determined by ICC Judge Prentice. I in that case was acting for the company, which had applied for an administration order, and it proposed the appointment of two IPs from different firms as joint administrators. Now, one of those two IPs had been engaged by the company between March and April of 2021. Then their engagement was terminated and they were re-engaged in the September. What had happened in the intervening period is the company transferred away most of its valuable assets to new companies incorporated by the directors and controllers of the company. So one can see why creditors may have had a degree of suspicion or concern as to whether that had been done properly and for full value. And also one can see why the creditors may have had concern about the appointment of that particular IP as an office holder, given that they were suggesting they consider the purpose of administration could be achieved. And if one was being charitable, could say had been less than quizzical about the events in the intervening period. Now, by the time we got to court, you had a large different number of cabals of creditors who are arguing slightly different things. So firstly, we had Castle Trust, which was a floating charge holder, but there are issues as to whether or not the floating charge was a qualifying floating charge, because the security didn't bite over the whole of the company's assets. They represented 1,500 investors who were owed about £118 million. And what they said is that they supported the administration application, but they wanted the joint appointment between the second of the company's nominees, so the IP who'd not had any prior involvement with the company, and their own nominee. We then had Strategic Advantage SPC, which, as its name suggests, was a Cayman Island segregated portfolio company. And its segregated portfolio was owed £37 million. And it sought the appointment of administrators from FRP. FRP themselves were already the administrators of another company in the group. And in their capacities as administrators of that company, they supported their appointment, and they had the support of other secured creditors and a number of other unsecured creditors as well. There was then, to complicate matters, an unsecured creditor which had presented a winding up petition, one of 4 petitions that had been presented against this company. And they said, we're happy for you to pick any one of the company's 2 nominees and any one of the 2 nominees from FRP, as long as you also appoint as a 3rd office holder an IP that we would like to have. So we think there should be a joint ticket across all 3. Now, the poor judge, faced with that, could have got into considerable amounts of detail into a lot of the learning, the law, the principles that we've seen, but Judge Prentice took a very pragmatic approach, gave a very short judgment, very, very short judgment in the circumstances. The matter was in front of the court in the applications list for, I think, less than half an hour, where he simply said, look, the likelihood in this case of any return to unsecured creditors is relatively remote. And even if there is any return to them by way of prescribed part, its magnitude is going to be significantly less than that's going to go to the secured creditors. So my primary regard as a judge has to be to the secured creditors, because they're the ones in whose interest this administration is being pursued. Castle is the largest secured creditor by a very large margin. It's owed 118 million. The other creditors together can't come up to half of that. Castle wants one of the company's nominees and its own nominee. That's the option that I'm going to go with. So standing back, in a different case where there were fewer potential appointees, I can see that the court may have said, well, actually, it seems that, for example, FRP seem the most obvious appointee here because they're the only ones who appear to be truly independent. And also they're already in office in respect of connected companies, so there's potential synergy there. And any conflicts of interest that may arise could be managed in the usual way. But the sheer volume, I think, of competing claims and, let's be frank, a slight sense of unseemliness that it appeared that some of the firms who were lobbying for appointment were doing so in their own economic interest, I think led to the court having to take the only pragmatic solution possible and just simply plump with what ended up being the company's preferred option. So surprisingly, actually, there was probably a number of creditors who may have felt disgruntled in that case, but nevertheless, that's what the court achieved. Obviously, in that case, everyone was offering up joint appointments as the option. On the next slide, we touch very briefly on the question of joint appointment, because you can see that if you've got a case where a more straightforward vanilla case where company says, I want A, and creditors say, we want B, and the company says, but A is already well advanced in the administration and knows the business very well, and B says, so the creditors say, we don't think that that A is truly independent, we want B because of their independence and integrity. You can see a temptation for the judge to simply say, I tell you what, joint appointment A and B, then it covers off all bases. The cases make clear that the courts should really resist that temptation, because appointing 2 IPs from different firms throws up potential increase in time and costs. There are issues as to how work will be divided between them. And in the absence of very compelling evidence from the parties before the court that actually a joint appointment can be achieved in a cost-effective, time-effective manner, it's unlikely the court will be persuaded to make such an appointment. Another potential spanner in the works is something which occurred in the High Street case itself as well, where some of the proposed IPs were saying, I am not prepared to take a joint appointment with this other IP. And so therefore, the option being put forward by that creditor is not a feasible option because I wouldn't be willing to do that. And again, if that could torpedo that being an option for the judge if ultimately the proposed nominees are not prepared to work together in any event. So, Govinder, do you want to draw all of that together into a pithy summary of where we see the relevant principles are?
Yeah, so the overarching point is what's going to be the best interests of the proper process of the administration, as well as doing justice to all those who are actually interested in the administration. So where we went up is that if it's creditor versus creditor, it's going to be the majority by value that's going to prevail, subject, of course, to this point about the time and cost points about a candidate who's already familiar with the company's affairs. That doesn't necessarily mean that that familiarity automatically puts the creditor out of the picture. It's ultimately the majority, that's the party whose benefit the administration is actually for. There's also resources, and the number of administrators are going to be relevant to that question. So that's going to weigh in the balance. But as a general rule of thumb, it's going to be the majority by value that's going to prevail. There's also the point that, and this applies across the board, if you can establish that there's a lack of confidence in someone's ability to conduct this thorough investigation, the court's going to be astute towards ensuring that justice is being seen to be done. What's not always appropriate is to hold this sort of head count of creditors to sort of decide between the company's choice and the opposing party's choice. But as a matter of practice, as Simon was suggesting, that a head count is likely to get you across the line in some of these more simpler cases. And we see in certainly more complex cases, what's perhaps more likely is the court's going to take a pragmatic view, stand back and say, well, actually, what's going to happen in this administration? Who's going to come out with anything? So it goes back to this sort of, who's the majority creditor in this administration? It's their interest really that are paramount, because this entire process is for their benefit. They're the only party that are going to get something out of it. And where that leads up to is, it's tempting to think of having a sort of tiebreaker solution that will make a joint appointment, one from A and one from B. It's usually going to be inappropriate because of the sort of time and cost implications. But if that is something which is proposed, then the sensible thing to do is to have, or to demonstrate that you've agreed strategy, or you've got some sort of division of labour, because what the court isn't going to be attracted to is the idea of A and B falling out or not being able to reach an agreement on the right way forward, and then having to seek directions from the court on an application. It's just going to go round and round in circles.
So I think we have 2 minutes left to cover off very quickly the question of costs.
Well, on the question of costs, if an administration order is made, ordinarily the party will be seeking that those costs are payable as an expense of the administration. The question is, what if you've lost the application? And there was a case, restructures and computers, where the court allowed the costs of a majority creditor who opposed a company's application for an admin order. Now, there were very, very strong arguments actually against the making of that admin order. And indeed, the majority creditor was going to be bearing the shortfall anyway. So what that case sort of suggests is that it's possible to get your costs as an expense if you can show strong arguments were made that the admin order shouldn't be made, and a prejudicial factor that's referable to the administration.
I think the one thing I would add is that while the court has a discretion at large to allow the costs of any person who appears to be paid, in my experience in practice, the court will often conclude that there should only be one pot, insofar as creditors have turned up and essentially been allied or argued the same position. I think unusually in the High Street Group case, the judge ended up allowing the costs to be paid of each creditor because they were taking slightly unique stances. It's worth noting as well that in the Tajik Air case, the directors were made personally liable for the costs of a failed administration application, which is perhaps at first blush surprising, given that such applications are usually treated as the application of the company itself for all intents and purposes. The test appears to be quite a high one, because the court will only require the directors to personally pay the costs where reason and justice require that. And that would usually only be the case where they have caused costs to be incurred for an improper purpose. For example, if they sought to obtain a private advantage at the expense of creditors or to conceal their wrongdoings. It's a strict test, but we simply query, would it be possible for the court to make a cost order where an administration application is made without the benefit of the advice and in the face of overwhelming objection? That seems to be an indication that is the case from the Land and Property Trust case, which is the final one we have on the slides. I think with classic counsel timing, we have overstayed our time by 1 minute. But if anyone does have any questions they would like to pose to us, then we'll remain on for another 5 to 10 minutes or so. You can either raise a question in the chat function, or if you're particularly brave, turn on your camera and ask it orally of us. Otherwise, that I think covers off everything we propose to talk about, and we thank you very much for bearing with us for the entirety of an hour, what I'm sure is a busy Wednesday morning.